Chapter 2. As to tenants in tail. The rule established by the cases where tenant in tail in possession pays off a charge upon the estate, is as broad as that laid down with regard to tenants in fee. Merger is presumed unless there is evidence of a contrary intention. It is said that the presumption is that, whether he takes an assignment or not, the debt is gone, as he represents the inheritance, and there is no charge unless there is evidence of an intention that it should continue an encumbrance. The fact of his paying off the charge creates a presumption that his intention was not to keep alive the charge, and in this respect the rule is as broad as that laid down with respect to tenants in fee. In Drinkwater v. Coombe, the rule is thus stated: if a tenant in tail pays off a charge upon his estate, the amount does not become a part of his personal property unless he manifest an intention that it should do so. And if tenant in tail, having the power at his own pleasure to acquire an absolute fee, and to defeat the remainder, does not exercise that power, it is reasonable to infer that the remainderman is in a sense the object of his own choice, and this is the reason of the rule for presuming, unless the contrary be manifested, that when the tenant in tail pays off a charge, he means the estate, which in effect he gives to the remainderman, should descend to him free from the charge. The rule, however, is not applicable to the case of a tenant in tail, who is restrained from alienation by Act of Parliament. The case of Shrewsbury v. Shrewsbury was thus: in 1742 the late Earl, with his own money, paid off portions charged by the settlement, and took releases for them. He never took any assignment of the term, nor was there any declaration of trust upon his so paying off the charge. He died in 1789, leaving a will dated in 1749, but without taking any notice of his right to be reimbursed this sum which he had discharged, or doing any other act by which his intention could be known. He was considered as a tenant for life, and therefore his personal representative was a creditor against the estate for the charge so paid off. Again, with respect to paying off a charge, a valid distinction is now established between a tenant in tail in possession and a tenant in tail in remainder expectant upon a preceding estate tail. If a charge is paid off by a tenant in tail in remainder, merger will not be presumed. Thus, in Wigsell v. Wigsell, in which this distinction was first taken, Susanna Wigsell being tenant in tail in remainder of an estate expectant upon the decease of her brother, Thomas Wigsell, and failure of his issue, during the life of Thomas Wigsell paid off an old mortgage due upon the estate, and took an assignment of the mortgage term to herself. Thomas Wigsell afterwards died without issue, and Susanna became tenant in tail in possession, and afterwards died without issue, and without having suffered a recovery. Sir John Leach, M.R., observed, where a tenant in tail in possession pays off a mortgage and declares no intention that the charge shall continue for the benefit of the personal estate, there the charge ceases, because the estate is considered as his own, inasmuch as he may make it his own by suffering a recovery. This principle has no application to a tenant in tail in remainder whose estate may be altogether defeated by the birth of issue of another person, and it must be inferred that such a tenant in tail means to keep the charge alive. When Susanna Wigsell therefore became tenant in tail in possession, this charge subsisted as a part of her personal estate, and not having afterwards declared any intention to the contrary, I am of opinion that it continued part of her personal estate at her death. This distinction was supported by V.C. Wood in Horton v. Smith, E. The court observing that Wigsell v. Wigsell had long been considered as sound law. In both of these cases the estate tail was an accession to the charge, which at the time of the accession formed part of the owner's personal estate, and merger was not presumed. We have seen that the rule of merger does apply where the charge is an accession to the estate by the tenant in tail in possession paying off the charge. There is, however, an intermediate case, where the charge and also the estate tail meet in the party at the same time. Thus, in Grice v. Sure, the party took the charge and also the estate tail at the same time and under the same will, and V.C. Turner observed, the general rule, indeed, is clear, that where a party has an estate in fee or in tail, and at the same time a charge upon the estate, the charge will merge, and he cites the cases of Donesthorpe v. Porter, and Lord Compton v. Oxenden, both of which cases, however, it should be observed, were cases of charges merging in the estate and fee. In Grice v. Sure, however, the charge was held not to have merged on the principle established by Forbes v. Moffat, viz. that merger will not be presumed to the injury of the owner of the estate. In most of the cases where tenant in fee and tenant in tail are said to be on the same footing with respect to the merger of charges, the observation seems to have been made with reference to a tenant in tail in possession paying off a charge, and in this sense no doubt the observations made in Grice v. Shaw are to be understood. Beside the distinctions made by Wigsell v. Wigsell, there remains another case, viz. where a person, without any act on his own part, is entitled to a charge, and he subsequently acquires the estate tail. The case of the Duke of Chandos v. Talbot was to this effect. The party was already entitled to the charge when the estate entail descended on him, and he afterwards died without having done anything to show an intention to keep the charge on foot. The charge was not merged, as the estate which came to the party entitled to the money, was only an estate tail. There is a dictum, however, of Sir W. Grant, in Forbes v. Moffat, which, as explained by V.C. Wood, in Horton v. Smith, is at variance with the case last cited. Sir W. Grant observed, upon looking into all the cases in which charges have been held to merge, I find nothing which shows that it was not perfectly indifferent to the party in whom the interests had united, whether the charge should or should not subsist, and in that case I have already said it sinks. Referring to this, V.C. Wood observes, Sir W. Grant is the speaking, not of a charge which the tenant in tail has created in his own favour by an actual advance of money, but of a charge created by some third person, and as to which the tenant in tail has never, either before or after the estate tail became vested in him in possession, expressed any intention whatever as to whether it should or should not be kept alive. In such a case Sir W. Grant says, it being a matter of perfect indifference to the tenant in tail whether the charge is or is not kept alive in the absence of any indication at any time of his intention on the subject, the court will assume that the charge was meant to sink for the benefit of the estate. The following is a summary of the distinctions which are submitted as warranted by the cases. 1. Where a tenant in tail in possession of an estate pays off a charge upon that estate, merger is presumed, unless there be evidence to the contrary. 2. Where a person becomes entitled to an estate tail, and also to a charge upon the same estate, at same time and under the same instrument, merger will be presumed in like manner, unless it would be prejudicial to him. 3. Where the estate tail is an accession to the charge, or in other words, when the party who acquires the estate tail is already entitled to the charge, the merger will not be presumed, but there must be evidence to prove the intention. In Trevor v. Trevor, Sir John Leach, v.C., held that a charge which had been paid off by a tenant for life was not merged by the accession of the fee. Whether the charge should be held to be subsisting in such a case where it can be of no importance to the owner of the estate and the charge, whether the latter merge or not, and his estate cannot be diminished, it certainly is reasonable to hold the charge subsisting where the estate tail is acquired subsequent to the charge, as it might be of the greatest importance to the tenant in tail to retain the charge as part of his personal estate, and he might die before the estate tail was barred, or before he had the opportunity of expressing any intention relating to it. A charge paid off by a tenant in tail under a misapprehension of his rights, will not occasion a merger of the charge. Thus, in the Earl of Buckinghamshire v. Hobart, a tenant in tail believing himself to be seized in fee, subject to a term for securing a charge, made a mortgage as of the fee, and out of the proceeds paid off the charge, leaving the term outstanding. It was held that, though there was an intention to destroy the charge, yet, as the whole estate could not, under the circumstances, be enjoyed according to the whole intention, the term, never having been assigned, should be considered as subsisting to secure the amount of the original charge. And in Kirkland v. Smith, a tenant in tail paid off an encumbrance on the estate, but took no assignment of the term to himself, and, apprehending himself to be owner and to have power to dispose of the estate and fee, he settled it upon his family. The persons entitled under the remainder subsequent to the estate tail, which had not been barred, claimed the estates, and it was held that the charge was not merged, and that they must make satisfaction to the personal estate of the tenant in tail. If tenant for life and tenant in tail in remainder join in a resettlement of the family estates, and family mortgages are paid off by the tenant in tail, and no assignment of them made to trustees for his benefit, they will be merged for the benefit of all the persons who are to take the estates in succession. If land tax be redeemed by the guardians of an infant tenant in tail, it will be held as a charge upon the estate in the possession of the remainderman, and in a suit instituted for that purpose the court will direct the persons having the legal estate to make the charge binding on the inheritance forever. And where a tenant in tail, who was also owner of the land tax, which had been redeemed, suffered a recovery and settled the estate, the charge was held subsisting. A separate account had been kept of the rents of the estate and the charge, and this afforded a presumption against the general words which the settlement contained, that the charge was intended to be kept on foot. A transfer of a charge to himself by a person who is not tenant in tail in possession at the time of the transfer, will not be considered as evidence of an intention to merge the charge. Although merger will be presumed in the absence of any evidence of an intention to keep the charge on foot, yet, if the acts of the tenant in tail afford evidence of such intention, the charge will be preserved as part of his personal estate, and parole evidence is admissible.